the request to the right agency, and once they confirm receipt, they get 30 calendar days to provide the information. A maximum of 60 if extra time is needed. Yes, I know you want access to everything, but sensitive documents are protected from the public for up to 20 years. For example, documents that would expose a citizen's personal privacy, or those dealing with cabinet discussions, the Governor General's office, or information on the investigative activities of the security forces. Any public officer who tries to destroy or hide any official document can be sanctioned. And if you're having difficulties, the ATI unit will help. So, what if the chemicals in the mosquito spray are toxic? What if the agency did not even try to get back the money they paid out? Call or email your MP. Share the concern, because as your elected representative, they can represent your questions to the government ministers in the House. Remember, it is the job of parliamentarians to monitor and hold the government to account on your behalf. Is not every country gives citizens this kind of power, you know? And at 20 years we have this law, and we barely use it. So access information and mind your business, Jamaica. Visit jampja.org today to see what information we access to make it easier for you to hold the government to account. Let's do our job to make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union in partnership with the Private Sector Organization of Jamaica.
Motorists, as Minister of Justice, I appeal to you, obey the road code, pay your ticket on time, and only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
Since 2016, 156,000 more Jamaicans are working. This is more than any other time in our history. Your government is caring for you.
Attitude is something which productivity will require, and a good attitude. So these are conversations which are difficult. Because how do you instill a good attitude? It starts by the kinds of activities that you engage your children in at an early age. What are we teaching our children even in our own homes? How do they see us reacting to challenges? How do they hear us addressing issues? That's what's going to shape their attitude and their mindset.
The following is brought to you by MOCA, the major organized crime and anti-corruption agency with kind support of NIA and USAID.
Criminal minds think they are cunning. The major organized crime and anti-corruption agency have them running. Your friend a shout, come scam. Take time running, because we ready for the ops. Drive up on your block, step out now me block. Cyber take about your laptop. Pull up every lock, no evidence a drop. We put it in a cuffs and now we have the underground. Sin you say scam, you better look out fit. When you move corrupt, better look out fit. They say you get wet, look out fit. Look out fit, look out fit. From you say scam, you better look out fit. When you move corrupt, better look out fit. They say you get wet, look out fit. Look out fit, look out fit.
The proceeding was brought to you by MOCA, the major organized crime and anti-corruption agency with the kind support of NIA and USAID.
MOCA, MOCA. What a flow, what a flow. What a flow, what a flow. Come on. What a flow, what a flow. What a flow, what a flow. The water put it just like a freestyle. The life block flowing mile by mile. It's legacy, a beat that don't stop like Bob Marley say. One love on top. The sewage water out of sight, but it's always wrong, don't lose the light. From factories and wells so deep, cause mangroves and fish they weep. Green water for the garden, keep it green. Save the cash and the earth gets clean. We use the water with a mindful mind. It's out of sight but never far behind. In nature, the answers always flow. Like water running pure, the cycle grows. It renews itself, same drop, same beat. It's all good, man, you got the heat. Water flow, water flow. No clean water, no pipes to grow. Protect our water, protect our future.
Time to go.
People always say government must be held accountable. But is whose job to keep government accountable, and what that really mean? Well, you see, when ministers and public officials have to provide answers for decisions made and can face consequences for those actions and decisions, that means they're being held accountable. Keeping government accountable is a key responsibility of our elected representatives, and the Parliament provides special tools or mechanisms just for this. As citizens, we need to understand how they work so we can play our part to ensure that the members of Parliament we elect are using the tools and doing their job well. Here are 4 of the primary tools you should understand and talk to your MP about. Tool number 1, Ministers' Statements. To effectively monitor the government, MPs need to stay informed. Every Tuesday when Parliament sits, different cabinet ministers are scheduled to give an update on decisions they're making on our behalf. These updates are called Statements by Ministers. They cover a wide range of national issues that other MPs, media, and citizens may have questions about and wish to examine further. That brings us to tool number 2. What you do when you want information? You ask questions, and that's why we have question time. Both opposition and government MPs can submit questions to the Prime Minister or Cabinet Ministers for details on, for example, how a contract was awarded or expenditure to purchase tablets for schools. So if you ever have a question for a government minister, try asking through your MP. After all, that's why they're your political representatives. They should represent your questions and concerns to the government. Tool number 3, Parliamentary Debates. When cabinet ministers present the government's proposals for new policies, laws, and programs, parliamentary debates allow both opposition and government MPs to air concerns, make suggestions, and endorse proposals. If you ever watch those debates, you know they can get a little fiery. But the debate is important as it informs decisions and continues until a vote is taken on the way forward. Then we have tool number 4, Parliamentary Committees. The general sittings of Parliament are not always sufficient for detailed examination of government work, so oversight committees are formed using government and opposition members to do just that. Some committees like the PAC and the PAAC are in place for an entire parliamentary term. Their job is to monitor the use of public funds to find ways to increase value and efficiency while reducing waste and corruption. Cabinet and state ministers are not appointed to oversight committees since they are a part of the government. Some committees are formed when a need arises. For example, joint select committees are formed to review draft policies or legislation or to probe other matters of serious national importance. Members of these committees are both opposition and government MPs and senators, and these committees will usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
Washing your hands properly can help keep you and others safe. Remember to wash often, especially before eating or touching your face.
Zoom in on the nutrition facts. It there in the table, on the side or the back. You fi check out the servings, just do the maths. Not
take in too much, figure build up the facts. So me on the nutrition facts. It they in at the table, on the side or the back. Take note of the sodium, the sugars and the fats. 5% or less in the on the right track. You for zoom in on the nutrition facts. It they in at the table, on the side or the back. Vitamins, minerals and vitamin 20% and more that good for you. You for zoom in, check the nutrition facts. You for zoom in, check the nutrition facts. You for zoom in, check the nutrition facts. Less sugar, less salt intake and less fat. You for zoom in.
A message from the Ministry of Health and Wellness, Jamaica Moves, the Heart Foundation of Jamaica, the National Health Fund, and Japan.
Me, I go show them my way of justice.
I'm abused.
I need legal advice. I don't deserve this.
The truth of the matter is, justice there for all of we. The Ministry of Justice has trained more than 5,600 persons in restorative justice practices. More than 200,000 victims have been supported by the victim services. Legal aid has reached thousands island-wide. Make we talk it out, not fight it out. Call 888 Justice today.
Today, we can report 2 consecutive years of reduction in major crimes and murders, with a significant reduction of almost 20% in murders for 2024.
Between January 2022 and January 2025, we have reduced murders by 51%, and January 2025 had the lowest monthly murder count since September 2014.
Our efforts have also resulted in the reduction of active gangs by 50%. We continue to increase firearm seizures, and in more communities, we are experiencing less violence. We will realize our vision of Jamaica as the place of choice to live, work, do business, raise families, and retire in peace and prosperity.
The proceeding was brought to you by the Office of the Prime Minister.
We want a piece for Jamaica. Yo, what are you? Oh man, none of that. Yo, no, brother, no, man. Can I see you ever play ref? Dirty game, man. Yeah, but like a bad game. No, I said, place when you come from, brother, I want to live good, man. I want to live good, brethren. No shake on, I can play like a bad, brethren. Really have to shake on? Yeah, man, and no badness, brethren. Just live good, man. Come together as one and make the violence done.
Tell me something. How much time you ever hear the government announce a project and wonder why they must spend millions on this and not on that? Well, if you think there's nothing you can do about how your money is spent, think again. Jamaica's budget is more than just numbers. It reveals our biggest problems and goals, our plans to fix them, and what to prioritize. We can even call it a promise book of what will be done to improve our lives. Now, let's talk about the 4 stages of the budget cycle so we can understand how it works and get involved. Stage 1, planning and review. The Ministry of Finance sends out a budget call to every ministry, which outlines the priorities and constraints to guide how those ministries prepare their budget. After ministries submit their drafts, the Finance Ministry reviews, compiles, and sends them to Cabinet for review and approval. Stage 2, Parliamentary debate and approval. The Finance Minister tables all budget documents in the House of Representatives. The Standing Finance Committee, which is all 63 MPs, sits to examine the budget documents, and each minister presents their budget and answers concerns the committee has. The committee's report is then tabled in the House, followed by the estimated expenditure, which is tabled as legislation called the Appropriations Bill. That's right, the budget of Jamaica is law. The budget debate formally opens. We have presentations from the Minister of Finance, the Prime Minister, Opposition Leader, and the Shadow Finance Minister. After their presentations, our MPs vote for or against approval. Like all legislation, it goes to the Senate for their approval and then to the Governor General for his royal assent. No later than March 31st, end of the financial year. Stage 3, implementation. The new financial year begins and approved budgets are sent to ministries. Collecting taxes, borrowing loans, and receiving grants begin. And so does the spending. Stage 4, budget oversight. Now, this is where citizens don't need permission to get involved. Throughout the year, operations and spending are assessed by internal auditors and the Auditor General's department that makes sure public entities are compliant with laws and that their financial reports are accurate. all Auditor General reports are submitted to our Parliament's Public Accounts Committee for review and cross-examination of public officials. The Ministry of Finance, Integrity Commission and MOCA also monitor government spending to guard against poor financial management and corruption. It is our job to review these reports, check the findings in the newspaper, and look up if breaches are fixed at jampja.org. If not, ask your MP what he or she has done to ensure public officials are held to account. No more 9-day wonders. So, did the government follow through on their spending and investment promises last year? What promises will next year's budget have? How will they affect you, and how can you ensure that you get what is promised? For access to the national budget, check out JAMP's easy digital version and contact info for your MP at jampja.org. Then link your MP and see what progress is being made throughout the entire budget cycle. Support JAMP. Let's do our job to make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union in partnership with the Private Sector Organization of Jamaica.
The budget is made up of expenditure and revenue estimates that are tabled in the House of Representatives at the same time by the Minister of Finance and the Public Service. The expenditure is the projected costs to cover the country's loans to public bodies, public debt, non-wage expenditure, wages, salaries, and capital for the financial year. The revenue is the total sum of money that the government will collect or raise to fund its expenditure for the financial year. The major revenue items include taxation, non-tax and capital revenue, grants, capital development fund, and loan receipts. The national budget is everybody's business because it impacts every Jamaican. Visit mof.gov.jm for more information.
A new story is being written for all Jamaicans. The Ministry of Economic Growth and Job Creation is on a mission to transform lives. From increasing access to potable water, to providing secure homes for the most vulnerable, and helping you own a piece of the rock. We're revitalizing communities and preserving our environment. We're making an impact. See the difference. Feel the difference. Building a better Jamaica for you and me.
You can feel it. Make JC.
Motorists, as Minister of Justice, I appeal to you. Obey the road code. Pay your ticket on time. And only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
We are the youths united against corruption, changing the world and the way we function. The youths united against corruption, changing the world and the way we function. You remember the youth, them are with future leaders, policy creators, decision makers. As if them are not just the cornerstone, but a crucial part to a better tomorrow. United against corruption, changing the world and the way we function. The youths united against corruption.
A message from the Integrity Commission.
Most major illnesses that affect Jamaicans are caused by unhealthy lifestyles. Over 50% of Jamaicans are overweight. 1 in 3 Jamaicans has high blood pressure. 1 in 8 Jamaicans has diabetes. 17% of Jamaicans have high cholesterol. A healthy lifestyle can reduce the risk of most of these diseases. Things like regular exercise and adequate rest can play an important role in maintaining good health. The other major consideration is eating healthy. The question is, how do you walk into a restaurant or fast food outlet and identify the healthier menu items? Better For You is an initiative to help Jamaicans to eat healthier. Restaurants and fast food outlets can voluntarily participate by identifying the items on their menu that meet the food-based dietary guidelines for Jamaica. These menu items would be easily identified with the Better For You logo, so customers can quickly identify healthier meal options by looking at the menu or menu board. Once they see the Better For You logo, they can confidently order that menu item, knowing that it's a healthier choice. Better For You will help Jamaicans to make better choices and prompt restaurants to add better options to their menu. Better For You is better for everyone. Good health begins with better choices.
What if I told you that you own thousands of acres of land, more than 100 companies with over 100,000 employees and billions in the bank? Well, I have news for you. You do. Jamaica belongs to you, and you need expert protection to safeguard those assets for your future, your children, and your children's children. And you already have it. A key protector is our Auditor General, whose role is outlined by the biggest, baddest law in all the land, the Constitution. The Auditor General's main job is to examine the financial reports of all public entities to ensure that they are accurate and that public funds are used appropriately and effectively to deliver public goods and services without waste, theft, and mismanagement. Here's how it's done. A team of highly trained auditors reviews and verifies that the right amount of money is spent on only what's approved in the national budget and in accordance with the laws and policies that protect public resources. Now, the right amount of money can be spent on the right things and Jamaicans still no benefit. So the Auditor General assesses the outcome for programs and projects as well. Audit reports will also contain recommendations to improve the operations of the audited entity, and the findings are submitted to the Parliament's Public Accounts Committee, the PAC. Every year, an annual report is submitted by December 31. Both government and opposition MPs serve on the PAC, and they summon public entity managers to answer questions so that they and the public, the real owners, yes, you, can understand what went wrong and how to prevent a recurrence. What are some things that can and do go wrong? Cost and time overruns, missing financial reports, unreported losses, unauthorized spending, unsupported payments, unlawful contracting, undisclosed conflict of interest, and more. Though the AG identifies the abuse of laws and policies, the law does not empower that office to penalize or sanction, but it does empower the Financial Secretary in the Ministry of Finance. It is also the duty of other anti-corruption and law enforcement bodies to grab the button and investigate to ensure penalties are applied when appropriate. But the AG alone can't watch all. So when things don't look straight, the Minister of Finance, members of Parliament, Cabinet, public servants, and importantly, you must blow the whistle and the AG will look deeper. So this is where you come in, with 4 things you can do to strengthen those who are fighting to protect our future. Tune into PBCJ on Tuesdays for the PAC and mind your business, Jamaica. It's our belongings, but we have to move like we understand that. And next time you hear a news report about the AG, you just left it up to the media. Visit the AG's website at www.auditorgeneral.gov.jm and check out the findings yourself. Then, keep track of how government has fixed the issue or not at www.jampja.org's Accountometer. And if you're not happy with what you see, it's your job to contact your employees. It's easy when you visit the MP tracker on jampja.org. This is how we can do our part to make Jamaica land we own, Jamaica land we love, and Jamaica land we run well. A message from the Jamaica Accountability Meter portal, funded by the European Union and UK Aid.
Young Jamaicans up to 35, your government will reserve up to 10% of NHT housing solutions over the next 5 years, just for you with 100% financing up to 15 million Jamaican dollars. This is how we are empowering and breaking the cycle of poverty meaningfully. Your government is caring for you.
The proceeding was brought to you by the Office of the Prime Minister.
The budget is made up of expenditure and revenue estimates that are tabled in the House of Representatives at the same time by the Minister of Finance and the Public Service. The expenditure is the projected costs to cover the country's loans to public bodies, public debt, non-wage expenditure, wages, salaries, and capital for the financial year. The revenue is the total sum of money that the government will collect or raise to fund its expenditure for the financial year. The major revenue items include taxation, non-tax and capital revenue, grants, capital development fund, and loan receipts. The national budget is everybody's business because it impacts every Jamaican. Visit mof.gov.jm for more information.
A new story is being written for all Jamaicans. The Ministry of Economic Growth and Job Creation is on a mission to transform lives. From increasing access to potable water, providing secure homes for the most vulnerable, and helping you own a piece of the rock, we're revitalizing communities and preserving our environment. We're making an impact. See the difference. Feel the difference. Building a better Jamaica for you and me.
You can feel it. Make JC.
Motorists, as Minister of Justice, I appeal to you. Obey the road code. Pay your ticket on time. And only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
We and the youths united against corruption, changing the world and the way we function. The youths united against corruption, changing the world and the way we function. Yo, remember the youth, them are we future leaders, policy creators, decision makers. As if them are not just the cornerstone, but a crucial part to a better tomorrow. United against corruption, changing the world and the way we function. The youths united against corruption.
Message from the Integrity Commission.
One thing we need to remember is that there are many persons out there in our family, community, wider society who may be having challenges, and that these persons sometimes need to be heard, sometimes need to be helped, sometimes need to be hugged, right? And the best we can do to promote mental wellness in our community is just to be there for people, to be able to hear them, to be able to hug them, to be able to help them, you know? And let's all be our brother's keeper and make this place a better place and a place that is conducive to good mental health and mental wellness.
The government expects to collect revenue, raise loans, and utilize cash resources to finance the central government expenditure budget. The money to fund the budget comes from taxation, for example, income tax, education tax, stamp duties, general consumption tax, among others. Non-tax, for example, profits in government companies and miscellaneous receipts by the Accountant General. Other sources of funding include Capital Development Fund transfer, capital, grants, and the Consolidated Fund. In essence, most of the country's funding comes from revenue and grants, loans, and from prior year cash balances in the Consolidated Fund. The national budget is everybody's business because it impacts every Jamaican. Visit mof.gov.jm for more information.
How do bills become law in Jamaica? Laws are made to create order,
to ensure our safety, and to protect our rights against abuses by other citizens, organizations, and even the government itself.
A bill is a proposal for either a new law or for a change to an existing law. Jamaica's Parliament is responsible for making our laws,
and that responsibility is shared between two houses.
There are 21 parliamentarians
appointed from both political parties to the upper house, also known as the Senate. And there are 63 members of parliament that we, the people, elect to the lower house, also known as the House of Representatives. To pass a law, there is a minimum of 6 stages required in each house. the process can begin in the upper house by a senator or in the lower house by your member of parliament. And their proposals for a new bill can certainly start with you, the citizen. Now, since the process often begins in the House of Representatives, let's start there. 1. The first stage begins with the introduction by the minister responsible for the bill, followed by the first reading of the bill by the clerk to the houses. This clerk is more like the CEO, the Chief Executive Officer for the Parliament. An announcement of the bill is published in the Gazette. This is a public newsletter that the government uses to inform the citizens of what the Parliament is doing on your behalf. 2. The second reading begins with a summary of the bill by the minister. The main reasons for the bill are discussed both by the government and opposition members to determine if Jamaicans would really be better off with the new law or changes to an existing law. A vote is taken by the House to determine if the bill will move to the committee stage. Sometimes before going to that stage, the minister responsible for the bill can recommend the use of a joint select committee. It's called joint as its members are taken from both the upper and lower house. To benefit from greater consultation, the committee is empowered to invite the public to share their views of the bill in writing or in person, and does so through radio, TV, and newspaper adverts. This Joint Select Committee submits its recommendations to the House of Representatives. The House debates this report, and a vote is taken to determine if the bill should go on to the committee stage, where it is examined by a committee of the whole House. Yes, that's the name. And that's what it is, a committee of all the members of Parliament that carefully examines each clause and makes improvements to ensure the bill will achieve its objectives. As chairman, the Speaker of the House monitors the process to make sure the rules of the House are obeyed and the process moves along smoothly. 4. The Committee of the whole House examines the bill clause by clause, then sends its recommendations for changes to the House of Representatives. This is called the report stage. 5. The bill then passes to the third reading to allow a final opportunity for MPs to make changes before it is sent to senators in the upper house. 6 to 10. In the upper house, the senators go through the same steps we just described. If any changes are made, the bill has to be returned to the House of Representatives for their discussion and approval. Now, if the bill had started in the upper house, it would also have to be returned to them for approval of any changes made by the lower house. 11. Throughout the entire process, the bill is being checked by the Legislative Council. That's the Parliament's lawyer. But before the last step, a copy is sent to the Attorney General of Jamaica for final review and certification. 12. If all is well, the bill is sent to receive the royal assent from the Governor General as the representative of the Queen, Elizabeth II. The bill is now an Act of Parliament. The Act is gazetted, and the rights of Jamaicans are further preserved and protected by a new law.
Hi, everyone.
Discussion about the role of the Integrity Commission and in this review. We ask that you help us to put our partisan views aside, focused only on the pledge that we have made to Jamaica to do things which will enhance the state of governance in our country. We thank you for all here present. We thank you in particular for the technical team, those who guide us and assist us as parliamentarians in carrying out our duties. All these things we ask in your name. Amen.
Thank you very much, Member. A little housekeeping matter. Member Marlo Ford has asked that she be allowed to join us virtually. And members, if it so meets your approval, The chair has no difficulty with the request. Do I have the concurrence of members? Yes? Thank you. So Member Malahoo will join us virtually. We have a few outstanding matters from yesterday for which we're expecting some guidance. We will take them just after we allow Member Scott Motley to... No. She wants to make a comment. And the chair has given her the...
Chair, I was not here yesterday when the issue of the Auditor General's removal from the Integrity Commission was discussed. And I thought it very important to place my views on the record. And you will permit me just to go back a little bit in time, because there was a time when I was of the view that she ought not to sit. And in fact, we had a meeting.
Sorry, can you avoid the she or he and rather speak to the
certainly.
position? Yes.
It is so good to be able to say she in a prominent position, however, in public office, because it does inspire all the other women here to think that they can achieve that too. But the Auditor General, let me shorten my response by saying that I have examined the situation very carefully, that I see no conflict of interest, as has been put forward by some persons, that the Auditor General, from the time of the inception of any body which was designed to prevent corruption or detect corruption, the Auditor General has always sat on that body. In all of what I have heard no instance cited in terms of inappropriateness or a conflict of interest. And if there is no overwhelming submission to that effect, then I'm not moved from my position. I hear Member Warmington behind me, because although I think he thinks he's being quiet, I can hear him. And my understanding is very clear that the Auditor General does not audit anything to do with the Integrity Commission. The Integrity Commission is audited by independent auditors who carry out that function. And indeed, the terms of reference for any independent auditor is determined by the person making the reference to the independent auditor. So those are the comments which I would like to be on record as stating my own view. Thank you, Chair.
We allow the member to make her comment, and we have accepted the comment in the spirit that she has made it, and we move on. So now, can we move to Mr. Peter Simmons?
Morning, members of the committee. The question was asked through Member Charles yesterday as to whether or not we could find any examples in other legislation, as whether or not there are any time limits as to how far back an Integrity Commission could go when investigating declarants, as well as whether they were restricted to their times, the declarants were restricted to their times during public life, or whether it was restricted to whether they're involved in acts of corruption. The short answer to all three questions is no. We couldn't find it in any other legislation. We looked at Trinidad, Guyana, Australia, and Dominica. Thank you.
Thank you, Mr. Simmons. Any comments? No?
Just out of curiosity, having regard to the fact that we had a long discussion yesterday about the Turks and Caicos, did you look in that particular jurisdiction to see?
No, we didn't look at that jurisdiction.
Okay. Okay, I think SG had, yes. On the issue of the judgment, to recall that yesterday, yes. Team, we just want to clean up what might have been outstanding yesterday before we take on the matrix as we have it.
Good morning, Chairman and members and colleagues, members of the committee and colleagues. I received a copy of the formal judgment. There's actually a decision, meaning reasons, but that is not available yet. It has not been finalized by the judge, but I did get a copy of the formal judgment, the orders. I sent a copy to Mr. Nash not long ago, so it can be circulated to the chair and members of the committee. But I'll just read. It was in the matter of the Integrity Commission Act and in the matter of Section 7 of the Integrity Commission Act before Honorable Mr. Justice C. Stamp on the 17th day of February 2024. I'll just read the orders. A, it is declared that Section 7 of the Integrity Commission Act, in particular Section 7.2, in its interpretation, mandates that any person or body must cooperate with the Commission in the exercise of its functions under the said Act or any other enactment. B, it is declared that Section 7 of the Integrity Commission Act, in particular Section 7.8, as interpreted, means that any body or any person or body cooperating with the Commission shall not be prevented from so doing by virtue of any law that provides for secrecy or any other restriction against the disclosure of information, save for on the grounds of legal professional privilege. C, Barita Investments Limited is directed to comply with the Integrity Commission's request made pursuant to Section 7 of the Act in letter dated June 28, 2021. D, the Integrity Commission is permitted to keep confidential the relevant attachments that accompanied the request dated June 28, 2021, made by the Commission. And each party bears its own costs. Those were the orders made by the court.
SG, could you read the first part of the order, because I asked a question yesterday if these were broad and general, and this suggests, therefore, that it is general, if I heard correctly. But could you read the order again for me, the first part of it?
Yes, so, and we had said yesterday that it is general and applies generally in the Act, but it is declared, A, it is declared that Section 7 of the Integrity Commission Act, in particular, Section 7.2, in its interpretation, mandates that any person or body must cooperate with the Commission in the exercise of its functions under the said Act or any other enactment. And then B, further, it is declared that Section 7 of the Integrity Commission Act, in particular Section 7.8, as interpreted, means that any person or body cooperating with the Commission shall not be prevented from so doing by virtue of any law that provides for secrecy or any other restriction against the disclosure of information, save for on the grounds of legal professional privilege. But what's important is C, where the judge ordered Barita Investments Limited is directed to comply with the Integrity Commission's request made pursuant to Section 7. Now, that request, as I understand it, was a very specific request from a specific director in a specific circumstance. And so this is where we get granular now into when we talk about a request from, say, the Director of Information as opposed to like the Director of Investigation. And so even though Section 7 is applied generally, it is still done within a context within the Act. So it was one specific director that would have made a request, and it's that the court is now saying that Barita must comply with that very specific request. So I'm saying all of that because yesterday we were discussing whether the orders can be applied just generally, let's say to all persons, or to all entities, or to all financial institutions. And I think the answer is no. The orders will always be very specific to each applicant and to what the request was.
I may seem to be going at this ad nauseum, but if Part A and Part B suggest that, yes, every entity has to cooperate with the Integrity Commission, and based on what we discussed yesterday in terms of who had the ability by law to get certain information, the Director of Investigation vis-a-vis the Director of Information and Compliance. A and B suggests that anyone can get it. So no, anyone can get it. But turn on SG's mic.
I'm saying I agree. Oh, I agree that anyone can get, or well, not just anyone. There are specified persons that can get it, but for specified purposes. It can't be just carte blanche. So the request that would have been made to the entity, to the financial institution, would have been specific from a particular director in a particular situation. And that's what I'm trying to say, that it's still, in the end, it still ends up being specific, and it's not something that is transferable or can just be widely applied.
Okay.
I'm not sure if I'm making myself clear.
I think I'm of the opinion that the legislation is a bit ambiguous because the SG has a particular interpretation of the legislation, but when you read the legislation in and of itself, it really doesn't give you that interpretation directly. So I agree with your interpretation, but reading it, another person may not have that interpretation of it. It may appear to be general. So it is for us to determine how it is that the legislation should be applied and amend or do what is necessary to make the legislation specific to what it is that we want it to say. I'm of the opinion, especially since we discussed it yesterday in relation to information and investigations, that they're two separate entities having separate functions, being able to do separate things. But reading it, no, I don't get that from Section 7.
So that's the point, and that's why even the court went further. So Section 7 gives a general power, but that power then now has to be
applied specifically.
You undertake that, you apply
but I think Section
power.
7 should speak more to how it should be applied, because as it is now, it doesn't say.
But I don't think it has to, because, okay, so...
And maybe that's why the Integrity Commission is applying it how they are applying it now. Not
so
specific.
I'm going to just say, I'm just going to just explain why I have my interpretation, why I think the court even made these orders, but I'm also going to say something else. I always say a rule of thumb, if persons are discussing something, a provision of an act, a lot, and if we can come to more than one interpretation, it means there is an issue, and it means we should clarify it. So that's always my fallback, and I'll accept that. But even the court then went on, not just to give an interpretation of Section 7, but then it went back to the request. And the request would have come from one of the directors. And that director would have said, in exercising my power under section whatever of the act, I am requesting this information to undertake these functions. So they would have had to explain the request and why they're making the request. And they need that power now to be, they want to be able to exercise their power under their section of the Act, but use Section 7. So I understand that it seems a little unwieldy, maybe, or it's, but the point is the general power has to be used in a specific way, and the only way they can use it is using under their powers, under their sections, because they have different sections where they have different powers that they can undertake. So the powers that are given to the Director of Investigation is not the same as the powers that are given to the Director of Information. And so I think that is even why the court then would have had to go further to then say, you now must comply with the request, the very specific request, but do it, and the court made the order pursuant to Section 7. But I take your point. If we are discussing it this much, perhaps then it means we should be looking to see if we can provide more clarity. Yeah.
SG, I have a problem with how it's worded. And although I appreciate what you say that in writing, one ought to specify, and I emphasize ought to specify, this section which empowers the director, I have to ask myself, what if there is a request made by someone who does not have that authority, but it's not questioned by the person who receives it? Because in truth and in fact, the reason why we are having this discourse around a case is because in this instance, the person said, no, I'm not giving you. But the person could have said, fine, here it is. And information which ought not to have been shared with the IC under any circumstances would be able to be received by them. So I think that we need to make it absolutely clear the circumstances under which such a request ought to be made and ought to be granted.
Okay, so yesterday, what we did was to provisionally tick this recommendation from the Permanent Secretary's Board, pending these further and better details that would have been provided, A, by Mr. Simmons, and secondly by the SG, and to be further discussed by members. I'm of the view then that, that this provision will be accepted as recommended. And that the guidance to, well, of course, I can only take it to where we have authority, and that is to recommend to Parliament. And in that context, I just want to make a general point for the public to appreciate that the understandings that this committee arrive at during our deliberation does not constitute a decision by the Parliament or the government, or doesn't guarantee that the action that will flow from recommendations that we make are secure. So we would guide utterances that sometimes suggest that there is a determined position that will be in law, strictly on the basis that the committee might have recommended. I think it's an important point to be made. Thank you. Mr. Simmons?
Yes, Mr. Chair, I just think for the record you should specify which item on the sheet that you are provisionally.
Okay, that will be number 7 on page 316 of the matrix. Right, so Member Chuck, you are our narrator. Can we move to the next? I think that's number 8. Yes? Yes.
Turn on the mic. Number 8, in relation to the appointment of members of the commission, in relation to section 818 is recommended, I'm just reading over, to make the office of the Auditor General a consulting body for the commission and not a fixed appointee. This was Jamaicans for Justice making that recommendation, in which case section 7 of the Act is sufficient to allow this. Jamaica Lands, Section 18, allows the appointment of persons who represent, onto page 4, non-governmental organizations that appear to be well established. It is proposed that this is removed entirely or at least amended. It is further suggested that it should specify that only representatives of NGOs, non-governmental organizations that are not foreign funded may be eligible. That is, representatives of foreign funded NGOs should be disqualified. This is from Jamaica Lands, by the way. While we understand and appreciate the point of Section 8.2, we are concerned about the uncritical acceptance of NGOs as somehow more trustworthy than political organizations or other categories of persons who are not listed as being eligible for appointment to the Integrity Commission. In Section 8.2, there should be more scrutiny of the NGOs, especially regarding their source of funding. Observation and concerns. Section 8.2 refers to NGOs as organizations that are not formed for political purposes or for supporting an organization formed for political purpose. But there's no definition for political purposes in Section 2 or Section 8 of the bill. Section 8.2 notably says nothing about foreign funding. Best FM made these points. It as relates to Sections 8 to 15 and the appointment of commissioners by the Governor General. This provision requires amendment to accord with the recommended status as an independent agency. The Norman Mandela Law School opined that it should be amended to ensure that any senior retired public official appointed to the Integrity Commission is not recently retired. He or she should have been out of public office for some time, and they recommend 3 years. The PSOJ observed or put in this query. In Section 8.1b, are these really the best categories of people to be sitting on the commission? Why is there no category for individuals of integrity, diligence, sound judgment, and impartiality from the private sector? Recommendation in Section 8.3, it is recommended to have the implementation of some fit and proper criteria for the position of commissioner. Mr. Warmington's position was dealt with yesterday, so we don't need to read that. So that is Clause 8. Mr. Nash.
Chair, I just want to, I'm sorry, Chair, but I just wanted us to go back to 7. Is it that we're saying that we are accepting the recommendation of the Permanent Secretary's Board to allow Section 7 only to relate to the disclosure of information in relation to an investigation? So that's what it said?
No.
No, but I'm saying that's what it said. So I'm trying to figure out what is the correct thing.
What we recognize is that there was a need for the act to be tweaked. And that, I think, is what members have been suggesting, that yes, there is need for it to be tweaked. The appropriate language will have to be found by you, Ms. Brown, and Mr. Simmons. But I think you get the sense of what the committee wants there.
No.
And I think that's probably what is worrying you.
Yes, I'm not following the amendment to Section 7.
Right. So, in other words, the acceptance of the Permanent Secretary's recommendation is not in totality, because members have looked at and seen that there are areas, right, that are okay, fine, yes, but then there are other areas that are not. And so what is being sought in the end is for a language to enable the law as it relates to the protection of the right of the individual is preserved. I think that's the issue in the end. Yes, SC?
So what exactly is the amendment being proposed to Section 7?
I think it's fair to say, Mr. Speaker, Mr. Chairman, in fact, from what the SG also commented on yesterday, that it must be interpreted to mean that if you get the consent of the member for verification, there's no problem. But if the IC needs to verify information, it can get that
from the
either from the consent of the person or from a court. Yeah. Is that my understanding, SG? In other words, the IC should not be at large where it can just get information without some sort of understanding of what the Privy Council case said. Can you elaborate? Because my understanding of the Privy Council case is that the only basis on which you can really ask a third party for information, first, if you're doing an investigation or you need information which is not forthcoming without getting it from the third party. Can you clarify that first, NSG?
I recall what you said yesterday with regards to whether it is a law that is needing to be fixed or it is the process, and that perhaps it is a process that we need to look at. But let me hear from you.
But I realize that it seems to be an issue with the general application of 7 and then how it relates to the powers being undertaken in sections, where are they now? You see, I think that is a problem, that there is no link. I think that's the issue. There is no signpost, there is no link with Section 7, and I'll find it in a minute. But my colleague to my left has been agitating for a certain position, which I just heard being said, where, okay, so right now, the Commission has a power where, well, it says a person or body shall, not me, shall cooperate with the Commission in the exercise of its functions, and it's all the functions, which is why this is of general application, and the court interpreted it in the literal meaning. But then 3 says the court may, on an application made by the Commission without notice, order any person or body to provide the information. So it is, the Act recognizes that a person may say no, and then the Commission now, to get the information, has to go to court, which is what they did. Yes. There is a view that perhaps persons should not be forced to hand over information, and so it should be done. And I think that's what Minister Chuck is also saying. It should be done either by consent or by a court order. And to my left, the view is being positive that it should only be done by a court order. So I'm going to throw it out there. I don't know if you want to elaborate on your point, because we are not policymakers. But I'll have Mr. Foreman just make the point.
Thank you. Well, based on the discussion as it developed certainly yesterday, my impression was what was conveyed by Member Chuck a few moments ago, i.e., if the Commission requests something from someone and that person doesn't want to hand it over, the Commission should still be able to get it, but they would have to get an order from the court compelling that production to be done. And in that connection, one could say that the court is serving as that sort of buffer between the privacy interests of the individual and the public interest to be served by investigating.
Which I think is what the Turks and Caicos case is.
And so on.
Isn't that what the Turks and Caicos case is?
Not in those precise terms, but the heart of it, though, or one central feature of the case is the concept that the Turks and Caicos Commission, in exercising its power to compel production of a document, must have proper grounds for doing that, right? It must be pursuant to some suspicion of wrongdoing on the part of the person, etc. And as part of the reasoning of the Privy Council, right? And part of the reasoning of the Privy Council was that the the structure of that commission is slightly different to how ours is structured. My reading of their legislation and also the way the court described it, it is that the commission itself has all of the powers to investigate and so on, whereas in our structure, we've split up the responsibilities into distinct entities within the commission itself. So the commission in the TCI case was exercising the powers to summon persons, to call on persons to produce documents, etc. In our legislative scheme, the Director of Investigation can do so pursuant to powers that are similar to powers under the Commissions of Inquiry Act. That power isn't given to the Director of Information and Complaints, right? So if the Director of Information and Complaints wants documents and the person doesn't consent to that, to providing those documents, then they would have to go the Section 7 route. Certainly, as I read that section, the court order should come into play if that director wants documents about a specific person and that specific person is not providing the documents. Now, Section 7 doesn't say that in express terms, right? So, I mean, one thing that the committee may want to consider is whether the commission, in the exercise of its powers to compel cooperation with other bodies, when that cooperation involves the disclosure of information related to the privacy of a third party, must go the route of seeking a court order, right? So in that specific situation, maybe the legislation should specifically say that's when you have to go court order route. Because there may well be situations where cooperation with another body does not involve disclosure of third parties' private information, right? The information director may simply want general information about rates as it applied at a particular point in time that they can't get through some other source. There's no privacy implication involved in something like that. That's general information. But I think an argument could be made that where the corporation involves the compelling of disclosure of third-party private information, then some sort of court order should apply there. And that's distinct, again, from the powers of the Director of Investigations, who has to exercise that power in a very detailed scheme that's set out in the legislation.
Chair. Chair, I'm in agreement with Mr. Foreman in relation to how it should be applied. The deliberations obviously confirm that we need to do some amendments to Section 7, because as it is now, 7.2 says a person or body shall cooperate, and then it says the court may, on application made by the commission without notice, order a person or body to provide information. And then it goes to 7.6, and it says nothing in subsection 3, which deals with the court, shall restrict the obligation arising under subsection 2, which says a person shall. And then it speaks to secrecy or other disclosure of information, where it is saying, notwithstanding any provision in the law and subject to subsection 11, no obligation as to secrecy or other restriction upon the disclosure of information implemented shall prevent a person or body from disclosing. So if it is that the application is the way, if we accept Mr. Foreman's proposal, quite a few of these sections will require amendment.
Chair. Mr. Foreman, I want to concur with what my colleague just said a while ago, but I'd like, if you recall yesterday, that Member Robinson indicated that he had gotten correspondence from the IC regarding some company that he was a part of up 10 years ago that he had even forgotten that he was. On what basis would the director of, not investigation, the director of information get that information based on what you just said a while ago? Give me a real life scenario.
Misinterpretation of the law and misapplication.
Can I ask a question which you can just answer at the same time? So, I know that you have a public register of companies, but my understanding of how the IC presently operates is that they will write to the bank and they will just ask for all of your accounts. So even if you have reported on an account, which is an active account, they will send to you information about an account which has in $0. Now, I have made an inquiry about why would that be relevant when you have the entire pattern of the account to see an account not being used. And I accepted the explanation that it can always be used once it's open. Now, people don't necessarily think of closing an account with $0. But I raise this in the context of saying on what authority, where it's simply for purposes of information or perhaps confirmation, that you can just write to the bank and the bank sends everything about you. Thankfully, sometimes bringing your attention to an account that you did not know your name was on, like your sister opened it and died, you know, that kind of thing. But in very practical terms, it leaves you feeling as though your privacy has been totally invaded when you are not under suspicion of any illegality. And I think that it is, our laws have to provide a balance. Because even though we want to eradicate or minimize or root out corruption, we still have to respect the fact that an individual does have some rights. And that even a communication to the person that I intend to write the bank to ask about your accounts would at least show some honor and respect. Now, the thing about, we can't make it seem that we want to criminalize people. We want people to comply. And therefore, the requirements of the Integrity Commission Act ought to confirm that what the Integrity Commission is seeking to do is to ask individuals to comply with the legislation, but don't necessarily make it appear that you want to prosecute a person when there's absolutely no basis for proceeding along that route.
Sorry. Can I just clarify something? And I think perhaps I'm looking back at, like, for instance, Section 6.2 of the FID Act. So what's in 7.2 is a provision that you have in other acts that establish regulatory bodies. So, for instance, the FID 6.2, every investigative authority shall cooperate with the division in the exercise of the functions conferred on the division. You'll find a similar provision in MOCA, and so on. And so the point is that is where 7.2 is basically worded the same way. The issue, though, is how it's being applied. And we're focusing on the fact that they are using this provision to be able to get private information on third parties from certain bodies. But note that this provision is also used for other things. So, for instance, they're able to enter into MOUs and other agreements and arrangements with other entities to carry out their functions, but not necessarily to get private information. So I have a suggestion. I recognize that there is an issue. I would still suggest you retain 7.2 because it has other purposes. But instead of saying shall, you use may. So a person or body may cooperate, and you may even decide if you want to leave it as wide as a person or body. You may want to decide the types of entities who may cooperate with the Commission in the exercise of their functions. Then when you get to Section 32, where you're dealing with the Director of Information and Complaints, or somewhere in that area, you now put in a provision that the Director of Information and Complaints, if that director needs information while undertaking functions under Section 32(1), and it would involve private information about a third party, then you say that they have to go to court to get that, or they could get it with the person's consent. Because I don't think you need to make any change to 48, which deals with the Director of Investigation, because that Director of Investigation now has very wide powers of the under the Commission of Inquiry Act, which you can understand because that person is undertaking an investigation. As it relates to somebody who is undertaking an information, if the committee is minded, then let them go to court and justify before a judge the fact that they need to compel the production of documents. That is another way to address it. But leave 7.2 and leave it to say may, because then that is the provision that would allow them now to enter into other arrangements and agreements with entities or bodies.
Chair, but SG, even if you are going to limit Miles, even if you're going to limit 2, right, and say may, or even limit the person or body to an investigative body, won't you still need a provision to say where that information concerns the disclosure of private information and that person refuses consent, then you do the court order?
So I don't think that goes into 7. I'm saying that, okay, the persons who are going to court would be who? It would be the Director of Information. He would have to go under Section 32. His powers are in Section 32. Let him undertake all his functions and powers under Section, well, it may not be 32, it may be 33, but in that area that deals with the Director of Investigation. I'm saying this more general area, let's take that. I don't think we should have the Director of Information and Complaints having to go and use a Section 7 power. So remove that ability. Give him now, or authorize that director when he or she would want the information, that they would now have to go to court. And it's drafted in such a way that it's clear that they would have to use a power under, I don't know where you'd put it, Section 32 or 33 or so on. Oh, so it's 32, under Section 32. And you make it clear then that 7.2, yeah, so I would say that it's made clear though that they don't use it for this kind of, the way they're using it now, that is not what you're supposed to use 7 for. So is it possible that then you should, I don't know, delete 7.2, because when I'm talking about arrangements, doing MOUs and so on, there are provisions for them to enter into MOUs and other arrangements in 7.12, but I think that would maybe have to be, if we are going to remove 7.2, we would have to look back at all the other provisions to make sure then that we're not taking away a power that they need, which is why I was sort of suggesting, and I still think it should be a person or body may cooperate. And then I'm not sure you would need, I think 7 will need some reworking, to be honest, but I still think the solution is to give the Director of Information and Complaints this authority under his section to be able to compel the production of documents by way of a court order.
No have a problem with that.
Okay, member.
No, just a brief comment. Yes. SG, it probably is a little unfortunate that you included the fact that it is in FID and MOCA and also here, because it gives a general impression, okay, that we are pursuing criminal acts right away. No, and not you necessarily, the fact that it is here.
It's different because they're only allowed to cooperate with other agencies. investigative agencies. Now, here, this went much wider. This spoke now about cooperation with, it said, a person or body. And in fact, it didn't even need to say our body, because a person, as defined on the Interpretation Act, means either the individual or a body corporate. So this went wider than what the other acts have, where those regulatory agencies are only empowered to cooperate with other agencies.
Okay, so committee, perhaps where we need to conclude on this matter is that in the generality, this recommendation finds favor. However, it has to be modified in relation to the discussions that we've had here today, and with particular the guidance from the SG and the CPC, and that we would rely on them to create the language to enable the amendment to be effected. Very well. Next item.
We are to make some decision in Section 8. What? So, in relation to 8, if I might start the ball rolling, I would recommend that we expand the list of persons to be commissioners to include, in one category, a senior attorney at law or senior chartered accountant.
But you have that now.
No, you don't.
Yes.
Where?
Well.
Look at it now. I'm looking at it. Huh?
Yes.
But it But I would restrict it. Right. It talks about a retired. What I would want a senior attorney at law, or a senior chartered accountant with at least 10 or 15 years practice. Yes, always, everybody retired. Why retired? I don't understand that.
I suppose it's the banking on experience and sagacity. SG?
So it's understood that the commissioners, it's not a day-to-day administrative job, but it is a big undertaking. So there have been two issues that have arisen, and I recall having a discussion with a former commissioner as well. Two issues that can arise. You have more risk of having conflicts of interest with someone who is still actively working. The other issue is you need someone who will have more time to devote to do the work as a commissioner. And a lot of times if you have someone who is still doing active duties elsewhere, the work of the commission could suffer. And that is an issue, not just here, but when we have been establishing other certain other entities. This is a little different as this Commission of Parliament, because you remember you also have day-to-day management and staff of the commission. And so the commissioners here are more like a board. More like a board. And so the persons who are doing the day-to-day would not be the retired persons. So the executive director, the directors, and other staff, they are not retired persons, but these commissioners who are basically acting more like a board, this is usually the preferred sort of way to do it, the scheme.
And well, SG, with due respect, as you quite rightly point out, it is the directors who are doing the day-to-day work. The commissioners, as you say, it's like a board. And most boards in anything meet once a month. I mean, you know, so I don't see why you need retired persons.
But the commissioners will tell you that unlike, let's say, other boards or regular boards, the work of the commissioners, it's heavy and it's tough, and it's not necessarily once a month and so. It's not light work. And that's been also an issue. It's very heavy, as far as, from what I have been told. And I don't doubt it, which is why I think you would also have an issue if you are, well, let me not say it that way. I know what the policy was, and that what I've said I know was part of the thinking behind the policy. I also have heard from persons who have been commissioners who have also said that it's true that the work is heavy, and it's, you need someone who has some flexibility with their time as well. But it's really for the members to decide.
I can appreciate what SG is saying in relation to the workload, but I think there are lots of other boards out there who carry a heavy workload and have board members that are actively working still. It's just a commitment that people make to their country. I think when you limit it to retired members of the judiciary, it limits the pool. So you don't have the flexibility and the option. I agree with having a senior attorney at law, because you can have a senior attorney at law in private practice that can provide that time and service to their country. Other boards have thrived. I don't think it will limit us at all, in my opinion. I've sat on 10 boards, and I see how people operate on boards, and I know it is time consuming, but it is still a rewarding feeling when you give back.
Chair, I pay more attention to the possible conflict of interest. And I think that when you put somebody who is retired and who is not actively engaged in the play, as it were, who is not interacting in that kind of way, you do insulate them against any possibility or suspicion of conflict of interest. And I think that although we are pointing to other boards, we have to understand the purpose and nature of this Integrity Commission. So I think that we should retain the retired persons.
But I don't think that the discussion is about whether you should retain the retired persons or not. It's perhaps what the member is suggesting is a skill set, that you're now looking to have a senior accountant, qualified chartered accountant as a requirement, and also a senior attorney.
Was why not somebody who is actively engaged? And that was what I was responding to. If that is not what he meant, then naturally I would withdraw my objections. What I'm emphasizing is the fact that the retirement requirement is a good one, which can only strengthen a body such as the Integrity Commission.
Team, I believe we could reduce the energy on this one.
Chair?
So
whilst reducing the energy, I think we should leave the status quo as is.
Right, because there is the issue of the status quo, and then, of course, the issue of expanding the range to allow for an enrichment of the committee through new skill sets that will bring value.
First of all, if you notice subsection B2, senior retired public officials. I mean, in other words, what about members of the private sector? That is why I mentioned a chartered accountant and a senior attorney at law. You see, a senior attorney at law, many of them may not even be fully in practice. And the same with many chartered accountants. I mean, one of the retired commissioners now was a chartered accountant in practice, and he didn't have a problem. And I think, Chairman, we need to expand this beyond retired public officials.
I just have one question, Chair. So, yeah, it's, Member Chuck, is it that you're saying, because you remember there are 5 persons on the commission, and you already have 2 retired judges who are attorneys, is that you want 3 attorneys three attorneys on the commission, if you're going to... Okay.
Mr. Chair, that's the question I was basically asking. What is the meaning of 8B3? Because my thinking, and I could be corrected, I think there is already someone from the private sector on the IC or who used to work in the private sector.
Or is it that they want it to be specified in the law and not left to the nomination of whoever the nominating agent or persons are?
Was the intention that
in other words, what they would want is a law which says that the members of the commission shall be 1, 2, 3, 4 skill sets. And then you pick whoever fulfills that.
I think we should.
It is there, but it is there confined to public, retired public officers. And that's what they're saying. So what the suggestion is that we can look at private sector retired persons as well, or even active persons.
There's already, I believe, a retired private sector person there. But I'm not sure what it means by...
Right, but was it stipulated that one should be there, or is it that one was appointed by?
No, it's not a stipulation, but I'm just saying...
But I'm understanding from members that they want some stipulation.
Okay.
Right, that's what I'm understanding. Yes? I don't think this one should detain us too much, members, yes. Sorry, let me have SG, and then member
so so we can help to move on. Because the views of the committee are you're going to delete A. You're going to delete A. So B would say it's 5 persons. And then you would list the categories for the 5 persons. Right. Okay, so I'm suggesting in 1, rather than 2 judges, you have it as 1 judge. You have the categories in 2 and 3, and now you would have space to add. You could add this chartered accountant, and you put in your qualifications for the chartered accountant, and you could add an attorney at law, private bar. Yes, a senior attorney with 10 years, at least 10 years. So at least you could add those 2 other categories, so you'd have 1, 2, 3, 4, and 5.
Yes, member Guy.
If you look at precedents, let's look at Mr. Wayne Powell, who is currently a commissioner, or was. He was never in the public sector. No. Yeah, he was never in the public sector. He worked with Scotiabank, unless Scotiabank is considered a prominent non-governmental organization that appears to be well established. So we have a precedent where somebody who has never been in the public sector has been appointed, and it depends on how you look at how you interpret what 8B3 says, because he doesn't fit in any other category. So I am just saying, as I said, Chairman, I don't think we need to tinker with this particular provision here.
But you do need to tinker with it if 8A is being deleted. Right, so then the issue then is what other categories would you now introduce? So you would want to introduce a chartered accountant. So this is and there can be an explanation for the person you're talking about based on their CV. That it can be that they would have had to fall within one of the categories. They have to fall under one of the categories. 3 is not as, it's not as wide as everybody thinks it is. It isn't. So I'm saying take the opportunity, this is what you have now, rather than have a debate about how you can interpret a provision. Notice I backed away from 7, even though you can have an interpretation. If there's a lot of discussion about it, take the opportunity to make it clear. So you have the opportunity now to add your categories from whom you can pull your commissioners. You're going to have 5 commissioners, have 5 categories.
Okay, we'll take
Point.
one final point on this. And then we move
I think it's important for us, especially if the proposal to remove Category 1 is accepted by Parliament, that we put a chartered accountant. I suspect that may have been one of the reasons to have the Auditor General there. But you need a chartered accountant, whether that person comes from the present tree, but a chartered accountant. And then instead of 2 judges, we could put 2 judges or senior attorneys at law. Add senior attorneys at law too. Or even retired attorneys at law, as the case may be.
Okay, I'm getting the sense, committee, yes? I'm getting the sense that there is need for a revision of this particular element of the Act to Section 8 to redefine the skill sets required for the appointment to the Commission. Oh, next item. Item 9.
Disqualification from membership. First of all, Jamaica Land spoke about persons must be of good moral turpitude. That is clear. The Commissioner must be of sound moral turpitude. The point, I'm at page 6, number 9, and I'm looking at disqualification from membership of the Commission. Best suggests 8 to 15, and the appointment of. I read that already, didn't I? No, and then Norman Manley's proposed that Section 9 should be amended to specifically disqualify persons who recently held or hold office in a political party, but that's clear from Commission membership. The Integrity Commission recommended that Section 10 of the Integrity Commission Act provides that an appointed commissioner shall, subject to the provisions of the Act, hold office for a period not exceeding 7 years and may be eligible for reappointment. I think we did. And then, no, that's it for the directors. Mm-hmm. At the moment, they're appointed for how long, Chairman? 7. So I wouldn't suggest we change it. We just leave it as. So 9 remain as is. So we go to 10, the tenure of office. Yeah, we'll leave it as is. 10 is the same point. We'll just leave it as is, Chairman. Chairman, there's not really much debate as to sections 9 to 15.
with that.
Go ahead then.
Chairman, we're working from this document, right? Okay, so I don't know if my colleagues are also using the matrix. Yeah, because this is truncated. So if you're just looking at this, as I obviously incorrectly was doing, you're not getting the sense of what the issue was in what is captured here as a recommendation. The recommendation at 9 from the Norman Manley Law School speaks to the appointment as a commissioner of persons who held office in a political party. And I think it is qualified as, sorry, let me just look at the, right, who recently held or hold office in a political party from commission membership. Right. And what are we saying about that one? I mean, I think.
No, but I think the current situation is it's silent on that issue of whether an appointed commissioner could be someone who previously had held a position in the political party. So I suspect what the Norman Manley Law School is saying, it must be precise to say no, they would be disqualified.
Is the Act currently silent on that, though?
The Act didn't say, right. The Act merely indicates the categories. But it didn't say, for example, that someone who had been, let's say, a member of Parliament 15 years ago, 20 years ago, or a leader of a party
right.
10, 15 years ago. It didn't quite say that. So I suppose what is being asked is for us to be precise about that and to indicate clearly that that person would be disqualified.
Very well.
Move on. Pardon? No, the decision was, I think, that we would not have made a change, right? Member Chuck?
Yeah, but the same with 10, Chairman. It repeating the same thing about the appointment and disqualification
Yes.
and term.
In other words, what is doing here now is to relate this to the commissioners,
Exactly.
which we had
Everything
dealt
is
with the directors earlier, right?
So, to be frank,
so just retain as is.
if there are no changes being recommended for sections 8, 9 to 15, we could move. Yeah.
Just to be clear, we are saying, and I'm looking on 10 now based on what has been recommended by the Norman Manley Law School, that the recommendation to provide greater clarity to the construct of that section is rejected as not necessary.
Well, that's the sense we get from the committee, but if...
Because I think it is very simple. It's just suggesting that the technical team glance on section 10, which reads, an appoint... Well, it says section 10. Am I wrong?
Sorry, SG. While the member...
I'm sorry, but I don't see any, I think the words are clear. I don't think there's any ambiguity.
Yes.
And when I look at the first...
9 or 10?
10.
10. An
10.
appointed commissioner shall, subject to the provisions of this act, hold office for a period not exceeding 7 years.
And may be eligible for reappointment. So your term of office is 7 years and you're eligible for reappointment. And that's how we draft all our laws. I see they suggest that one interpretation could be that the period of 7 years could include the period of reappointment. That's very,
well, I just
very
raised it in case there was some
no, so we had looked at it. So we had looked at it,
yes.
sorry.
No, I was just raising it if there was any suggestion as to an alternate construct that could provide some greater clarity. But if not, then good. Accept it.
So,
Chairman,
we are at 11?
11, no, Chairman. If I might say, we continue. When you look at 11, 12, 13, 14, 15, we can sum up 15. This is the Integrity Commission proposed that Section 15 should provide, without reference to the Governor General, that an appointed commissioner may be removed from office only for inability to discharge a function of his office, whether arising from infirmity of body or mind or any other cause, or from misbehavior, and shall not be removed except in accordance with the provisions of subsections 2, 3, 4, and 5 of this section. Best FM noted, as it relates to sections 8 to 15, and the appointment of commissioners by the Governor General, this provision requires amendment to accord with the recommended status as an independent agency. The categories of persons from which such appointments can be made should not include two groups of retirees.
Yeah, we went.
Younger and more current day prospectives are required. Additionally, the process of appointment should include public hearings, and candidates should be proposed by both government and opposition members in equal numbers. The chairman should be selected by the confirmed commissioners at their first meeting. The position of executive or managing director should be open to foreign nationals. Conditioning amendments to all relevant sections will be required. I would say we say no to that proposal from Best FM. Yeah. That's number 14. Sorry, I was at, yes, or is it number
Chairman.
15.
Chairman.
Go ahead, Member Malahu.
May I just ask Member Chuck to just repeat the rationale for the request from, was it Best FM, he said?
I can only read what they say, not the rationale. What
in
they said,
in the matrix that you are working with.
Do we have a copy of the matrix?
Right, it's here, and I think we can find it quickly for you.
It's 15.
Yeah.
15? Actually, it is the first 15. There are two.
Best FM, right. So, yeah. Yeah, man, it's just, this is a complete. But what is a should what? See, it stops. Yes. You have it? Okay, SG, okay. Thanks, SG. Because we have it here, but it's truncated at a point that didn't make a lot of sense.
Right. The recommendation, as it relates to sections 8 and 15, is that what we're doing, right?
Yes.
From Best FM, the morning connection. As it relates to sections 8 and 15 and the appointment of commissioners by the Governor General, this provision requires amendment to accord with the recommended status as an independent agency. The categories of persons from which such appointments can be made should not include two groups of retirees. Younger and more current day perspectives are required. Additionally, the process of appointment should include public hearings, and candidates should be proposed by both government and opposition members in equal numbers. The chairman should be selected by the confirmed commissioners at their first meeting. The position of executive or managing director should be open to foreign nationals. Conditioning amendments to all relevant sections will be required. Commissioners should be considered public officials for all purposes and should be ineligible for other public office once their tenure has ended. This would avoid the potential for any conflict and misuse of information obtained while serving in that capacity.
So, Chairman, I have noticed, may I go ahead?
Yes, please. You have the floor.
Right. So I have noticed increasingly there is a call for public hearings and confirmations around certain appointments. And while while one can understand the desire to have greater say, I think it's equally important to note that we're seeing a commingling of two forms of government, right? So there is a different style and a different process of doing things under an executive presidential system as opposed to a parliamentary cabinet system. So where you have the executive presidential system and offices, most offices are elected office, even judicial office, and other offices require Congress confirmation. Increasingly, you're seeing a creeping in, or some members of the public are asking for that style. I just want to say that we have to be so careful how we proceed to deal with these kinds of requests, because we can throw our system into a kind of chaos for administration that may be more harmful than helpful. So while I fully appreciate any concern that is raised that will require that concern being addressed to give greater confidence in the public, I think it's also important for members of the public to understand how a parliamentary cabinet system, a parliamentary system of government works as opposed to the executive presidential system.
Very well. Member Chuck, I see. Yes.
Well, Chairman, I think, as I said, we could go straight to page 9 and section 27.
So the decision is to not accept this recommendation. Okay.
But Chairman, may I just ask that what is the concern that the the group making the submission has about the current process of appointment? What is the real concern?
I don't think they have any concern. They were just making a recommendation.
I see.
But they've set it out. They
Right.
set it out in the matrix.
Right.
Yes. Dr. Guy?
No, it's not related. It's a housekeeping matter. The volume from the online is quite startling to the ear, and it will damage our ear here. So we ask the Parliament to turn that down a little, please.
Chairman.
Yes, Member Campbell.
Just a query as to the Integrity Commission's comments in relation to Section 10. What is our position on that one? Did we deal with that?
Yeah.
It was talk. I didn't think we dealt with that. Did we?
Yes, we did, and we decided to leave the law as is.
For Section 10?
Yes.
They weren't
Because it had to do
for clarity.
It had to do with the 7 years, the tenure of the commission.
No, I'm reading the matrix. They were talking about the staggering of appointments.
What it says is that it is proposed that Section 10 should be amended to limit the tenure of the appointment of commissioners to a maximum of 7 years.
No, I am going by what is in black and white in front of me, and my matrix says Section 10, tenure of office, and I know that's what Section 10 speaks about.
Yes.
I'm referring the committee to the comments of the Integrity Commission under that section, and the comments in relation to a request for a mechanism to stagger the terms of appointments of appointed commissioners. I understand that to mean that if everyone is appointed at the same time, and their tenure ends at the same time, that the commission may well find itself in a situation where it lacks continuity and institutional memory at the level of the commissioners. That's something that is a difficulty on public boards as well. So I think what they're asking for is an appointment process that appoints some commissioners in one sitting and other commissioners at another time.
how is it currently done? Because the other day we had some commissioners retiring
at different
and some
times.
were reappointed.
Yes.
In
other words,
is it institutional?
Right. No, but apparently all 5 commissioners, their tenure is already staggered, isn't it? Because
that is what
because
I'm
what we had at the last time, the 2 members
Yes.
would have done their 7 years, and that right. So it is staggered already, and I think that's why it wasn't accepted. In other words, the system that exists now.
No, well, that's the question.
Right.
That's the question I'm asking, Chair, is what, I know that we had a staggering recently, but is that a function of chance, or is there an institutional process that says that some commissioners are appointed at one stage and others at another? Because you can end up with chance causing you to have a staggered appointment system simply because some persons may not live out their entire appointment.
Right. Well, I think members, this recommittal of 10 is useful because the question is properly asked, I think. We certainly would want to give the process an opportunity by law to correct itself. Although at the moment we are enjoying that staggering effect, but you're right, there's no guarantee that, that will continue. And what the IC is trying to suggest is that we should have a system that allows for this staggering for the purpose of continuity. And I think that makes sense. Yes? So we revisit Section 10 and accept the recommendation of the IC in this regard. Next item.
Just a reminder that they said that based on this, the Senate 8 to 15 should be reviewed together.
Yes, that's all right. But yes, just for that particular element of it, because remember 8 to 15 is being treated together, right? Except that we're saying that in the specific instance of the tenure of the commissioners, we could, exactly. Okay?
Member Golden was asking a question in relation to Section 50, the Integrity Commission, termination of the appointment. You see, the Integrity Commission had made a specific proposal that where an appointed commissioner is to be removed for inability to discharge the function of his or her office or for misbehavior, and shall not be so removed except in accordance with the provisions of section. But I suspect, isn't that automatic? Would you say that if a commissioner is to be removed in accordance with subsection 1, doesn't it follow that it must be followed, it is done in accordance on the section 2 to 5? Well, section 15. Right. They wanted. Oh. That is always the case, especially that the Governor General that makes the appointment. So I don't, exactly. So I don't think we should change it. Yes. So we don't accept that proposal. All right, I think we could move on to Section 27, Chairman, and leave 8. So we're going to allow 9 to 15 to remain. Slight changes to 8. Slight changes to 8 and 10, right? So we go to Section 27, Delegation of Powers by the Commission. Permanent Secretaries Board recommended that in relation to subsection 27.1, it is recommended that clarity be provided to the functions that can be delegated. The functions of the Commission are listed at section 6 of the Act. The reference to any other staff members seems too broad. The delegation of the powers of the Commission should be specific to the executive director, directors, and other senior staff whose posts should be listed. This is section 27, colleagues. So could you look at section 27? It speaks about delegation to the other members of staff. I'm not too sure that we should really want to change it, Chairman, colleagues. I think the idea is that you're going to go to the executive director, a director, or any other staff member. It could be another senior staff member. So I wouldn't accept that that recommendation. Look at it. 27.
I'm just going to say, just because an authority is given in the Act doesn't mean it has to be exercised. But what we have found with delegation sometimes is it's provided for very narrowly, and then it creates issues when an entity evolves. There are always changes. Things don't remain static. So things change, and then they realize they need some other type of assistance. They need to delegate, and they don't have the power. But just because the power is there, if they think it's not appropriate for other staff members, then you don't exercise the power. But to remove the power could create an issue going forward in the future.
Exactly. So we won't accept that. We won't accept that recommendation, Chairman. Is that okay, colleagues? So we'll move on. In 28, the Permanent Secretaries Board also recommended that section 28.4, that a specific period for reappointment be stated, and section 28.5 regarding termination of the appointment of the executive director for misbehavior or any other cause, due process should be followed and a tribunal established to facilitate a hearing. That's 28.5.
Let's look at 28.4.
28.4 speaks about a period of 5 years and should be eligible for reappointment.
Yes.
Did we discuss that it would go beyond 3 years?
Yes. We did say it could go beyond 3 years. So that one has been dealt with.
So we have dealt with that?
We have dealt with that. Okay. Take.
And in relation to the termination...
25.5 now.
The idea of setting up a tribunal, Chairman, I mean, here, once again, it's the Governor General who appoints.
Yes.
I think we should leave it as is.
No, but what they're asking, if I may, what they're asking is that it is not the commission, the recommendation of the commission, but the result of the tribunal, which will give the Governor General the necessity to terminate the appointment, as I read it.
With due respect, Minister, Member Morris Guy, the commissioners, the 5 commissioners, we hope are persons of integrity and judgment. No. What I'm really saying is that they have been working, say, with this executive director. They find that he cannot discharge a function. No, I'm just giving you...
No, you're not adhering to what I'm saying.
Oh.
I'm saying that the Permanent Secretaries Board is requesting is that there is supposed to be a tribunal established.
Mm-hmm.
But the point I'm making is what you are suggesting now, that I don't think we need to go that particular route, because we have people, as you have said, Member Chuck, that people of integrity who have worked with a particular individual
and who can make the recommendation.
And ought to know.
Exactly. Okay.
So we don't need to...
We don't need to change it, Chairman.
Senator Golden Campbell.
Chairman, just for clarity, if an executive director was terminated and the executive director felt the termination was not properly done, he would have recourse to the normal processes and procedures of the public service, would he not? But he would only... IDT and court, right? Okay, okay. And yeah, I shouldn't have said public service because I was really thinking IDT, but yeah, okay. So there is a tribunal that if there is an issue, there is recourse to.
But maybe for the record, I'm doing this. Just because the Act doesn't speak about a tribunal doesn't mean a tribunal would not be established. So generally with these types of matters, where persons are given this authority, they always, I don't know of any example that doesn't do that, they appoint usually 3 persons to sit to hear the matter, and they always include either a retired, someone with legal experience, so whether a retired judge or an attorney at law, to sit on that tribunal, most times to even chair that tribunal. And then the tribunal will then submit its recommendation to that person who has the authority to actually to take the decision. So even though it's not stated here, usually you have to they have a process, and that process is usually one where a tribunal is established.
Right, so we don't need to see it in the Act, right? So we can move on to 32, sections 32. We dealt with the reappointment, not more than 3 years. All right. So we go to section 32, the Permanent Secretaries Board recommended that 32(1)(b) read as follows: make such inquiries of the declarant as he considers. It is recommended a specific reference is made to the declarant. 32(1)(b). Or what they would like to put, make such inquiries of the declarant. This is of the Turks and Caicos, right? Well, this is the point, SG. What the Permanent Secretaries Board is saying is that it should make inquiries of the declarant. No, but clearly this allows them to make inquiries of third parties, which is what we are saying. When they do, they must get permission, which we dealt with earlier. Right, okay. So we can move on to section 40, Chairman. And section 40, the Integrity Commission recommended that section 44 of the Integrity Commission Act be deleted. On the face of it, this subsection can create a loophole and a potential corruption enabler. It is conceivable that a relative of a parliamentarian or a public official could be used as a conduit for the exchange of an illicit benefit designed to confer a benefit or an advantage to himself or another. That's 44. So what does 44 say now? Just for the benefit of all of us, subsection 44 says, subsection 3 first says, subject to subsection 4, and a parliamentarian or public official who receives a gift which exceeds in value the amount of $100,000 or such other amount prescribed by the minister by order shall declare the gift in the item specified as item 14 in the third schedule. Then subsection 4 says, subsection 3 does not include such gift as may be prescribed or any other personal gift that is received by a parliamentarian or public official from a relative of that parliamentarian, public official. I'm not too sure that the Integrity Commission is asking for that to be removed. I don't see why it should be removed. So if your grandmother or your mother gives you property as a gift, you know, I'm not too sure this is something that you have to declare it anyway.
Chairman, I understand the rationale that the Integrity Commission is putting, well, the rationale that they have in making this proposal. And to some extent, well, to some extent, it could potentially be a loophole. But the truth is there has to be a balancing of interests. And I think a proposal to delete 40 subsection 4 really intrudes into the privacy of persons in a way that I don't think is justified under this act, under the tenets of this act and what this act is seeking to achieve. Because you're then saying that, you know, husband and wife gifts must be declared. Mother and child gifts must be declared. And I do think that there has to be some protection given to the ability of families and relatives to have their relationships without it being published to the state or any entity of the state. I don't find there to be sufficient justification for this. We already have to declare motor vehicles, any land assets, accounts of that nature. So I think that is sufficient for the Integrity Commission to assess whether or not the public official is operating within their means and not the beneficiary of illicit gains. I don't think you need to know whether or not my dad paid for me to go on a trip to Paris, exactly. Which I wish he would if he's listening.
I don't see the basis why we should have this removed, Chairman. I mean, the Integrity Commission is saying that it is conceivable that a relative of a parliamentarian or public official could be used as a conduit for the exchange of an illicit benefit designed to confer a benefit or an advantage to himself or another person. I mean, yes, I don't know what colleagues think, but I don't see the need to remove this. I mean, it's not that it's a third party giving a gift, Chairman. It is your close relative who has given you something, and why should it be revealed to the public at large?
The point that Member Campbell made is that it would have to, in the normal run of things, be declared anyway. Because it would then constitute an accretion of your asset.
In the normal course of things, Chairman, gifts are revealed, you get me? Especially if it's a very expensive gift.
Yes.
In an event, Chair, this is really talking about now, in my opinion, for example, what Member Golding said, her father wants to pay for a trip to go to Paris, for example. My mother wants to give me a watch. I don't see why I need to declare that. But if it is that we're dealing with property now, for example, if my mother wants to put me on her title, I would still have to declare that to the Integrity Commission. So I can't conceal that.
It said, exactly, because
So
it does indicate any gift valued more than 100,000 has to be declared.
Well,
exactly.
So
you see, Chairman, that would really, let us assume that Member Hamilton's mother gives her a brooch, which could be very expensive. If you ask me, the Integrity Commission would want to ask for a valuation of the brooch. You know, if she declared I got a brooch from my mother, then the Integrity Commission might ask, well, we need a valuation on that brooch. So I really and truly, Chairman, I think this is asking for too much. I would not accept that recommendation. Leave it. I would strongly propose that we let it remain.
Yes.
So that's section 40.
So 41.
And that's 40. 42 is the next.
42, yes.
Yeah. In 42, Chairman, the Integrity Commission recommended subsections 1 and 3. It is proposed that due consideration should be given to defining or clarifying the words examine, duly we dealt with this.
We dealt with that, and I think there is a correspondence from the Commission which says that they have actually withdrawn that recommendation.
Very good.
So we can move on.
Yeah. So we go straight to 53, which that's the end of it. I think we've dealt with 53 already, Chairman. So that's the end of this matrix.
Okay. So we take a break while the clerk gets some things together and bring the next matrix, which has to do with some of the deferred matters that were not related directly to SG and her responses. I don't have the exact figure, but it's not a lot. We had it before. It's just what we've done is to extract from the big matrix. Right. Three categories. One is the category of those that we had approved, and that's one set. Then the categories of those that are deferred, and the others that are now for further reference. It's not an awful lot. We've really broken the back. We've broken the back of the work, and I think we'll have that in a few minutes. So we just take a break, have lunch, come back. Yes, we have to take lunch. It's a health break. So we're suspending the meeting for lunch and a lunch and break, and we'll come back in an hour. Well, lunch is provided here, so that may be used. No, man. No, man. Come back by 1:30. No. Okay? 1:30. If
Once upon a time in a Caribbean island known for its rich culture, natural beauty, lived a group of people who were buried in piles and piles and more piles of paper. Papers spanning back to the start of time. Then came a bright idea: harnessing technology to work smarter and not harder. The government of Jamaica is improving its operations to serve citizens better. Many services are now available online, and there's more to come. The government of Jamaica, building a better public sector for all.
It's Thursday, June 12th. In the headlines, government members push to remove the Auditor General from the Integrity Commission. In business news, Digicel's credit rating increases. Regionally, Caribbean leaders concerned about new U.S. tariffs. And in sports, U.S. Immigration and Customs Enforcement, ICE, to be deployed at FIFA Club World Cup venues. This is the news on PBC Jamaica. I'm Simone Absalom Gale. Members of the government on the Joint Select Committee of Parliament reviewing the Integrity Commission Act 2017 on Wednesday used their majority to push forward a recommendation by St. Catherine Southwestern Member of Parliament, Everald Warmington, to remove the Auditor General from the Integrity Commission. Currently, Section 8 of the Act mandates that the Commission includes the Auditor General as one of its commissioners, along with 4 others appointed by the Governor General after consultation with the Prime Minister and the Leader of the Opposition. Mr. Warmington has repeatedly argued that the Auditor General's membership on the Integrity Commission breaches the Constitution. He further suggested that Parliament erred when it included the Auditor General as a commissioner on the revamped Integrity Commission.
Section 120, 121, and 122 of the Constitution makes it clear of a responsibility and can be a part of any of the board or bodies. So, in effect, this is a breach of the Constitution in including her as a commissioner, based on Section 120, 121, and 122 of the Constitution. And this is the basis in which I recommend that, the Auditor General be excluded as a commissioner.
During Wednesday's committee sitting, government members contended that the Integrity Commission, which receives nearly $2 billion annually from the state, requires the level of rigorous auditing that only the Auditor General's department can provide. At present, the Commission is audited by an independent accounting firm. But Mr. Warmington and other government members believe this arrangement is insufficient, given the volume of public funds involved.
Based on as Member Hamilton says, the type of audit done by the Auditor General is completely different from the audit you get from private individual. You need performance audit and all of those, and those external bodies do not go in depth a complete audit and report to Parliament as is required by the Auditor General. And that's Section 120, 121, and 122 make it clear.
Government Member of Parliament Tova Hamilton, along with Senator Shireen Golding Campbell and Minister Pernell Charles Jr., expressed support for the proposal to remove the Auditor General from the Commission.
Chair, I would support the proposal for the Auditor General to be removed. The reason I believe that a third party is used currently for audits is because the Auditor General is a part of the Commission. So if it is that office is removed from the Commission, then the Auditor General can undertake the necessary audits as it relates to bodies of that nature.
Chairman, I made it clear probably well over 2 years ago that I am in support of the Auditor General being unfettered from the Integrity Commission so that she's in a position to audit the Integrity Commission as she does many other government agencies?
The question was asked of me a while ago of my position, which is supportive of what was said by Member Golding and Member Warmington. But I want to make it clear for those who are listening to us that when the matter of potential conflict, if you call it that, has been raised, even the perception of it is problematic, even if it were not to be seen as real. The perception of it in itself is also problematic, and if we can avoid that, then we ought to do so.
But two opposition members present at Wednesday's committee meeting, Dr. Morris Guy and Julian Robinson, objected.
I don't have a difficulty with the Auditor General being a commissioner of the IC. If the basis is that the AG audits that particular commission, I don't think it is done by the AG.
I would say I support the Auditor General remaining a member of the Integrity Commission, and in my understanding, where audits are done of the Integrity Commission, they're done not by the Auditor General's department, but by an independent accounting firm, which removes that issue of a conflict of interest. But I would not support her removal from the Integrity Commission.
The committee is set to reconvene on Thursday to finalize its deliberations and prepare its report for Parliament. Chairman Edmund Bartlett indicated firmly that the committee will recommend eliminating the Auditor General's role on the Integrity Commission. The government is in the process of documenting more than 27,000 kilometers of road in Jamaica, and a number of these roads will be officially named. Making the announcement on Tuesday, Prime Minister Dr. Andrew Holness says this special program will guarantee that roads island-wide have the proper names and addresses. He was speaking at the ribbon-cutting ceremony for the Myton Gully Drainage Improvement Project in Old Harbour, St. Catherine.
Because if you look on one map, one road is spelled another way, you go to another map, it's spelled another way, and that all the addresses are properly unified. So that is a special program that will come out of the proper documentation of our roads.
Dr. Holness says the documenting process will also ascertain which authority, namely the National Works Agency, Rural Agricultural Development Authority, or the municipal corporations, has responsibility for the various roads, eliminating the occasional issue that arises when roads need to be repaired.
First thing, we go and we do a proper accounting for the road. Because before, people would call about their road and you couldn't even find it on a map. It is a no register. Nobody knows about the road. It's a dispute sometimes. Sometimes you say, this road needs to be fixed. And when you go to the MP say, no, this is a parish council road. And when you go to the parish council, they say, no, this is a NWA road. And then sometimes you go to the parish council and say, this road needs to be fixed. And the parish council says, no, there's a farm road.
He notes that in some instances, when a road is laid in a subdivision but was not handed over to any authority and therefore was never registered, the Prime Minister outlined that once the documentation process is completed, all roads will be assessed and ranked in order of priority, depending on their state of disrepair. He says, however, that not all damaged roads will be repaired at the same time.
It's going to take you at least a decade to repair roads that have not been repaired in 50, 60 years, some of them, or ever, since they were built.
Jamaica's education minister is pushing back after a troubling article from The Gleaner reported that most first-form students at the Pembroke Hall High School are reading well below their grade level. Portfolio Minister Dr. Dana Morris-Dixon says the ministry has launched several island-wide initiatives to tackle low literacy rates. Danita Rodney has the story.
Jamaica's education minister is addressing growing concerns over student literacy following reports that 70% of first-formers at the Pembroke Hall High School are reading below grade level. Speaking during Wednesday's post-cabinet media briefing, Dr. Dana Morris-Dixon says the ministry has rolled out several initiatives to boost literacy rates in primary and secondary schools across the island.
It's always sad when you see those reports, and it is the reason why we are focused on literacy. And you would have heard me announce that come September, from grade 1 to grade 3, we are timetabling reading. It had been taken off of the timetable some time ago, and we are putting it back on the timetable because we cannot afford for our children to leave primary school not literate. So that's our policy position. Now, we have instances like this where students are entering into high school that are not literate. And that's why we've put in some new programs. We call it the tactical approach, where we're focused on literacy in those schools that are challenged. And so our reading specialists are working with them.
The education minister is urging primary schools to get on board with the government's push to boost literacy rates, saying their cooperation is critical to improving student performance nationwide.
And so there are more interventions like that we need to do, but we also have to work with the school leadership because we do have a board, we have a principal in all of these schools, and it's very important that we showcase the schools where they have a problem at grade 3, and you see by grade 6 it has been addressed. And what that means to me is that it can be done. And with the right leadership and with them taking the tools we have in the ministry, that we can definitely, within another 3 or 4 years, we can eliminate this problem. But it takes the board to be proactive. A board has to be proactive.
Dr. Morris-Dixon also shared that the Education Ministry is working on improving the detection and treatment of students with learning disorders.
And we're starting a little bit earlier than the grade 3 test. And we are training our teachers to be able to pick up issues. And what we say to them is that when you pick up any challenges, you need to encourage the parent to come into the ministry, to come in and get a diagnostic test. Obviously, that's one area that we have to improve on because there's a long waiting list for the diagnostic tests, especially at the facilities we currently have. And that's why we're building a new facility, which will be open this year, in order to do more diagnostic tests. Because I don't know if any of you have ever done a diagnostic test.
Food handlers' permits will now be valid for 2 years instead of 1, starting January 1, 2026. Health and Wellness Minister Dr. Christopher Tufton says the move is part of a major update to the National Food Handlers Training and Certification Program. He made the announcement while addressing Parliament on Tuesday.
Some 300,000 Jamaicans each year apply for food handlers permits. And oftentimes they have to wait 3, 4, 5, 6 months for a permit that lasts 12 months. So as soon as they get it, they have to reapply. The process is cumbersome, it's bureaucratic, and it does create challenges for people who are doing business and require the food handler's permit.
The minister notes that delays in the process of obtaining a food handler's permit also impact larger businesses in the food production and fast food sectors. He plans to diversify payment options for fees.
Introduce convenient bill payment service option effective January 1, 2026. This idea of going to a place that is in a particular part of the parish, as opposed to going to a Paymaster or a Bills Express or or the bank or somewhere, is no longer relevant. Times have changed. And so we're going to be changing that.
Dr. Tufton also highlighted plans to implement a bimodal modular training format aimed at reducing certification processing time from 3 weeks to 2 weeks.
Introduce new technology to facilitate faster and more efficient processing to eliminate delays and backlog, and increase the cadre of professionally trained food handlers to reduce the risk of outbreaks linked to improper food handling. And finally, increase application access points, reducing wait time and enhancing delivery.
It should be noted that trained food handlers nationwide reduces the risk of foodborne illness outbreaks linked to improper handling. Time now for the Business Report with Denise Williams.
Welcome to today's Business Report. I'm Denise Williams, here to bring you the stories shaping the financial world and guiding your journey to smarter business decisions. Let's dive into the top headlines. S&P Global Ratings, the world's #1 credit ratings agency, says that Digicel will earn US $800 million by the end of its fiscal year, which gives it strong coverage of its current US $1 billion debt load. Digicel's credit score also improved because S&P analyzed the US $216 million the company will be spending on its infrastructure this year. Digicel also plans to spend a further US $240 million on infrastructure next year. Deputy Bank of Jamaica Governor Dr. Jade Lewis notes that compliance with the ATM standards has been a long-standing challenge, as the regulations related to uptime for ATMs has only been met once during the 13-month period, January 2024 to March 2025. Commercial banks are still struggling to have the country's 878 ATM machines functioning 95% of the time, or for 22 hours and 48 minutes each day, as is required by the central bank. Dr. Lewis says banks are also experiencing challenges in having ATMs in urban areas resuming operations within an hour after they go down. The required period for functionality to be restored to ATMs in rural areas is in 3 hours after a breakdown. For the trading period ending June 11, 2025, these were the most actively traded stocks. International logistics conglomerate Kingston Wharves Limited, with 9,962,826 units traded, represented 45.43% of market sales volume. Beverage manufacturer Jamaica Teas Limited, with 2,914,496 units traded, representing 13.29% of market sales volume. Toll Road Manager Trans-Jamaican Highway Limited, with 1,375,189 units traded, representing 6.27% of market sales volume. We now shift our focus to the Forex market rate set by the Bank of Jamaica. On June 11, 2025, the Bank of Jamaica reported US $87.05 million purchased and US $94.75 million sold by Forex traders. Forex traders earned 96 cents per dollar, selling the US at $160.15 and buying the US at $159.19. The Canadian dollar netted Forex traders 83 cents per transaction, with selling at $118.01 and buying at $117.18. The British pound yielded Forex traders $1.10 in profit, with selling at $216.45 and buying at $215.35. For our credit report tip of the day, retirement isn't a finish line. It's a financial phase that gets you to prepare for life on your terms. If you're within 15 years of retiring, now is the time to shift from survival mode to strategic mode. Your credit score isn't just for borrowing, it's a gateway to passive income, better health coverage, and long-term security. With the right moves, you can turn your good credit into great choices, the kind that protect your lifestyle and build wealth well into your later years. And that wraps up today's business report. I'm Denise Williams, reminding you that every financial decision is a step toward your future. Until next time, stay focused, stay informed, and keep striving for success. See you soon.
In regional news, Caribbean leaders are sounding the alarm over new U.S. tariffs, and they say they're threatening regional trade and economic growth. Speaking at the opening of the 60th Caribbean Community Council for Trade and Economic Development meeting, Barbados' Foreign Minister Kerry Simmons warned that the sweeping tariff hikes imposed by Washington in April are squeezing Caribbean exporters and could derail progress towards sustainable development.
Chairman of the CARICOM Council for Trade and Economic Development quoted, and Barbados' Minister of Foreign Affairs and Foreign Trade, Kerry Simmons, has highlighted the growing difficulties regional businesses face due to newly imposed tariffs by the United States on Caribbean nations. Minister Simmons was speaking at the opening of the 60th regular meeting of quoted on Tuesday. On April 1st, the U.S. enacted sweeping global tariff increases that included countries in Latin America and the Caribbean. Under the new executive order, most Caribbean nations now face a blanket 10% tariff, while Guyana was initially hit with a rate as high as 38%. Simmons emphasized the urgent need for CARICOM to evaluate how its exports can continue to access global markets with minimal trade barriers.
The recent tariff shocks are a stark reminder of the need for us to diversify our trade and economic relations. We must redouble our efforts to deepen existing and explore new markets and develop new partnerships if the region is to advance its goal of economic growth and sustainable development.
CARICOM Secretary General Dr. Carla Barnett also addressed the gathering, stressing that the region is confronting multiple trade-related challenges in an increasingly volatile geopolitical climate.
The question of whether our exports can enter markets with the least possible barriers and whether imports reach us in a timely, safe, and affordable manner all impact the performance of our economies and determines whether we thrive or struggle as a community. These considerations must be uppermost on our minds today and into tomorrow as we take critical decisions in our region's interests.
She underscored the importance of promoting regional production, enhancing intra-regional trade, and updating trade policies to foster entrepreneurship and simplify business development. Dr. Barnett also pointed to the need for resolving persistent trade impediments and eliminating long-standing issues of non-compliance that hinder regional integration. The two-day meeting concluded on Wednesday. Reporting for GBN News, I'm Beverly Tellis.
Barbados is stepping up efforts to overhaul its mental health laws in response to a growing crisis, especially among the nation's youth. Chief Medical Officer Dr. Kenneth George says rising cases of